Welcome to the third in a series of 10 CLE webinars. Today's program is titled Retirement Assets and Divorce. The presenters are Amy Wechsler and Judy Deere. Amy Wechsler is a family law attorney with Lawrence Law. Her practice includes collaborative divorce, mediation, arbitration, and parenting coordination. Amy has a BS in Child Development and Family Relations from the University of Connecticut, an MSW in Clinical Social Work from Rutgers School of Social Work, and her law degree is from Rutgers-Newark. Judy Deere is a licensed, one of these things that's just popped up on my screen asking me to buy something. Anyway, Judy Deere is a licensed New Jersey attorney and president of All Pro Quadro LLC based in Livingston, New Jersey. She's been practicing in the field of pensions and qualified domestic relation orders since 2004. There are materials associated with today's program. They were distributed at 8 a.m. this morning from a registration list as of last night. If you registered after that, you will receive the materials after the presentation. Amy and Judy will be taking questions during the presentation. Please use the Q&A function for asking your questions. The next big event is the annual conference on November 12th. It is a member benefit this year. That is, it is free to everyone who has paid for the 2021-2022 membership year. So please renew your membership now. On December 6th, there will be a CLE webinar titled Challenging the Ethics of Mediator Neutrality. The presenter is Dr. Rachel Field, who is a professor at Bond University Law School in Australia, and that will be a really good one. So, with all of that introduction, it's up to you, Amy and Judy. It's your program.
Thank you, Carl.
Thank you.
Welcome to all who are there. Thank you for joining us for this. There's a lot of material to cover. We'll get to as much as we can. I want you to really take a look at the materials you have, not necessarily while we're doing the program, but print them out, put them in your file. They're really valuable. They're put together by Judy and her team, and they're really, really good. So I'm going to start with some really basic stuff, and I hope that doesn't offend anybody, but I'm not sure how much everyone on the webinar really knows. So we're talking about dividing marital assets, not just any retirement assets, but those that are marital. So what's a marital asset? Generally, a marital asset is something that accrues from the date of the marriage until a date either when a complaint for divorce is established or another date is agreed upon. They don't have joint names, retirement assets. They're in one person's name. And they're different types. So there are defined benefit plans and defined contribution plans. The defined benefit plan is a benefit that's defined. So you know that when you retire, when you're 65 years old, you're going to get $2,000 a month. That benefit is defined. That's supposed to be guaranteed. So far, generally, I think they are. Defined contribution plans are when the contribution is established. So you know that you put in X percentage and your employer is able to match it with so much of a percentage in addition to that. But the benefit you get at the end is really going to depend on how you've invested those funds and how the market has dealt with those. So you don't know until you're taking them what they're going to be. So that's the way that the contribution is defined. There are also IRAs, which are not provided by employers. Individuals can contribute to their IRA accounts up to certain amounts each year. There are different rules as to whether you can do it if you have a job with a 401k. There are different kinds of IRAs, but they're not employer provided. So big important tip is when you're talking about retirement assets with your clients in mediation, identify which type of asset they are, and if they're IRAs, which type of IRAs they are. Because you need to know whether certain things are going to be taxed or not at the end. Also keep in mind that, especially with older clients at age 72, people who have retirement assets, IRAs, old 401ks, are required to take minimum distributions. They're called RMDs every year. So these assets are not necessarily going to be preserved. They might be for one party who's 72 and might not be, or not be for someone who's 72 because they have to use them. But you may have a spouse who's 62 who's going to have, another 10 years before they have to touch this. So those are sort of things to keep in mind, just information to know. How old are your people? When are they going to be eligible to get these kinds of assets? So just because it's a retirement asset doesn't mean it's marital. Ordinarily, if you have an asset before you get married, and you don't commingle it with assets during the marriage, it's going to retain its identity as premarital, will be exempt from distribution. If you have a 401k and you get married, you can't go to your employer and say, could you please now set up another 401k for me because I'm married now, and this one's going to be subject to equitable distribution, but the premarital portion is not. They don't do that. So the premarital portion has to be figured out at some point in order to know the marital portion at the point of distribution or at a point of divorce. So we kind of have to know those dates. Judy's going to talk a lot about what we need to know in order to draft the orders that are required in order to prepare and distribute these assets. So in mediation, you want to determine a cutoff date. As I said, the marital portion is from the date of the marriage until a date. So part of mediation is to say, we're not going to necessarily wait till the complaint is filed because maybe people don't really want to formalize the divorce for weeks or months or maybe next year. But is there a point at which the additional contributions that are being made by that spouse and the spouse's employer, whether or not those things are going to continue to be in the pot, or there's a cutoff as to figuring those out. So that's something that as a mediator, I think is important to discuss with your clients. So now we have to value the marital portion. So I'm going to turn this over to Judy for a few moments and say, when we have a defined benefit plan, what do we need to know in order to value that marital portion, if in fact we're going to value it?
Okay, yes, good morning all. Good afternoon, I guess at this point. Valuing the defined benefit plan is really only done by preparing a pension evaluation. Because what you're trying to find out for the benefit plan is how much in today's dollars is the benefit promised to this employee, of $1,000 a month upon retirement for the rest of their life. We need to put that into today's numbers. So what a pension evaluation will do for you is it says, this is how much money needs to be in, I say in the bank, but really in some type of investment, earning money, I generally use 5%, earning 5% over the participant's lifetime. How much money do we have to put in the bank today to pay out that benefit over their lifetime? If that is clear. So usually those are used, a pension evaluation is used for purposes of a buyout. If somebody is interested in keeping their entire pension at retirement and does not want to share it through Quadro. So how much money do they need to give their former spouse or the other spouse in order to buy them out of this pension? Or more importantly, it's used to figure out to secure a pension. We'll talk a little later about the police and firemen. Probably the only pension I know that does not have any form of survivor benefit for a spouse. So you would be looking to secure that pension by getting a pension evaluation. When you're dividing a pension, a defined benefit plan, you do need to look at various factors. I don't know if we're going into that yet, Amy. Are we?
Yeah, I think, well, yeah, I want to talk just for a few moments about valuing the marital portion of a defined contribution plan.
Yeah.
And then we'll jump to the distribution issues.
So define the contribution plan, as Amy talked about already. You know, probably the one issue that's always a little murky is the premarital, right? If you have a contribution plan that the person started in the account, either the 401k or the IRA during the marriage, and everything that's in that, you know, up until your evaluation date is marital, it's very simple. It's 50% of the account as of the valuation date. The premarital is the tricky part. If you're looking to back out the premarital, there's really two ways of doing it. If you have documents, if the person has their date of complaint, a date of marriage statement, that's terrific. Because now we have at least a starting point. But often, you know, people that are married 20 years, 25 years, they just don't have the statements going back. But if they do, if they happen to have, you know, be somebody who keeps all of their statements, they can do one of two things. They can take all of those statements, go to a forensic accountant, have them look at it, and determine the actual growth on the premarital, because the person is entitled to their premarital plus the growth on that premarital, which over a period of time can be a substantial amount of money. So if they have documents, that's great. They can have somebody either look at all of them to see what the premarital has actually done, or, you know, depending on how much the premarital is, if it's not, doesn't seem worth it to engage a forensic accountant. Sometimes I have people just agree on a percentage. Okay, you had $20,000 at the time of marriage. Let's agree to give a 5% annual compounding interest on that premarital through the course of the marriage. Back that out of the date of complaint or the valuation date balance. You can do that. So documents are great. Often people have nothing, right? The best they can do is say, well, I started working in my company in July of 1990. And that's when I started contributing to the 401k. In that case, what most people do is we do what's called a coverture fraction analysis, where we take the percentage of the account that accrued during the marriage versus the entire time the person's been in the marriage. We apply that fraction against the date of complaint balance. That's really the only option you have left when there's no documents available.
Right.
Other things, just be careful when you're valuing the contribution plans. We talked about the premarital. If there's a loan against the account, be sure to speak with the parties as to, is it a marital loan? You know, was it something taken out to buy a home? Or is it is it the participant's individual loan? Is it a loan they took out to hire their attorney, right? So you have to address the loan and then earnings or losses.
Right. Thanks, Judy. Some people want to offset plans against each other, particularly with defined contribution plans. So somebody has 100,000 in one plan, the other party has 200,000, the difference is 50. So looks like it's an easy thing to say, well, from one plan, we'll roll over 50,000 to the other. And that rollover, by the way, is there's no tax effect for that. Federal law allows for distributions of retirement assets without a tax problem or a tax impact. But the reality is that the day you decide that one is worth 100,000 and one is worth 200,000 and the difference of 50 is to be rolled over, it's true on that date, but by the time this order gets drafted, pre-approved by the 401k plan administrator, back to you, back to the judge to be signed, and then back to the plan for implementation, Those plans aren't worth 100 and 200 anymore. One of them might be worth 90 and the other one might be worth 220. So now $50,000 is not a fair way to equalize them. So I've had lots of cases where there are 3, 4, 5 401ks, IRAs, whatever. People say, let's just add them all up and divide by 2 and roll over half the difference from one to the other. And I really, really fight people on this because of the example that I just gave you. By the time there's implementation, the number you came up with is no longer fair. Somebody's getting more than half, which means somebody's getting less than half. And although it's inconvenient and a little bit more expensive, if these plans have substantial assets in them, we're not talking $2,000 to $3,000, but they have hundreds of thousands of dollars in them. Do the Quadro for each separate plan. It's $400 or $500. I'm not sure what they cost. Maybe there's a bulk discount if you have a lot of them, but you're going to get exactly half of each account distributed to both parties. And that's really the only way to be absolutely fair in this. So I fight people on this all the time, and it's just really important to get it right if you're trying to be fair. Also, if you're offsetting retirement assets against non-retirement assets, so somebody says, well, you owe me $100,000 from the house, so let's offset that with $100,000 from the 401k. No, because $1 in a house is worth $1. $1 in a 401k is worth 65 or 70 cents, depending on your tax rate. So you need to tax affect the assets that you're attempting to offset, if some have a tax impact and some do not. So that's just important to understand. There's a comment and a question. So some pensions may include medical benefits if 50% or more beneficiary, she believes this is government pensions, which Judy's going to cover a little bit later. How do you, one, find out if benefits can continue and then the buyout or split? Okay, that's with the medical benefits. I'm not sure the answer to that. Judy, or
no, I don't actually deal with medical benefits.
Well, asking if benefits can continue, and this is important, I think, for anybody who's working with people doing retirement plan distributions, especially with something that's a defined benefit, is to get the plan documents. And if those documents don't answer the question, have the participant contact their plan administrator and ask the question. There are answers to questions. We don't have them, but the plans do. So I always encourage people to get in touch with their plan administrators, their HR people, whoever is monitoring these things, if the plan documents themselves don't answer the question.
Right, yes. I mean, that's very good advice. I mean, I know the federal government, you can continue health benefits for a former spouse. State plans, I haven't seen that the health benefits continue to the former spouse. But again, as Amy said, you should contact the plan and get documents regarding that.
Right. So we're going to talk a little bit about distribution, which Judy started to get into a little bit ago. So these orders are called qualified domestic relations orders. Judy, what does the word qualified mean? How does that impact this?
Right. Well, so qualified means that the plan itself is qualified under ERISA, the Employee Retirement Income Security Act. And, that's, there's a lot behind that act. Basically, that act says a person's retirement assets are inalienable. You cannot go after their assets, in bankruptcy, creditors, retirement assets are secure, except in the case of a divorce. Actually, years ago, even in divorce, you couldn't go after them. But somebody finally decided, that doesn't seem right. So they amended it. So they amended ERISA, and they said there are three people that are allowed to go after a person's pension asset on any plan that's qualified under ERISA, which are generally your defined benefit plans, your pensions, and 401ks. And the three people that are considered alternate payees, that's the person who is under ERISA allowed to go after a pension, is, and this might be of interest to people, is first a spouse, not a second, a former spouse, and third, a dependent child. So a Quadro can actually give money to a spouse. The divorce does not have to have gone through. It can, of course, give it to a former spouse and children, dependent children. You can use a Quadro to get child support or child support arrears because it is going to a dependent child. So that's what qualified means, Amy, as far as how that's used.
Right. So we know that.
Say, what about non-qualified plans, right? Yes, and in those cases, we do domestic relations orders, and that is for IRAs. Now, some IRAs actually don't require a DRO. And we always tell people, and I think Amy, you'll probably speak to this, that you tell people to contact the IRA custodian to see, right? Isn't there another way of doing it without a DRO?
Right, and they'll provide paperwork that needs to be completed by the participant, the owner of the plan, or the benefit of the account, and you need to have your divorce judgment, so they know that there's this judgment in place that requires it, and whatever the it is, and we're going to talk about that, how it's defined in the order so that they know what to do. And it can be just a rollover from one account in one person's name to an account in the other person's name without a formal additional order other than the judgment of divorce being required. I have run into, and I don't know if it was Fidelity or Vanguard, that if that wasn't done within a certain period of time, then they do require the Quadro. So you need to let your clients know in mediation that whatever they're going to do, they need to have their lawyers do it promptly. And so one of the things also to do in mediation is assign responsibility to one of the parties to make sure that the orders get drafted and entered. The other party isn't going to sit by and watch, but at least someone is taking the reins in that. One of the things that happens on the other end, once a divorce judgment has been entered and the Quadros aren't done and nobody's paying attention, and maybe the lawyer was really only retained for the divorce, and a Quadro would require a separate retainer. Some people do it that way. It just never gets done. That creates all kinds of chaos. But even with just the plain IRA, if it's not done promptly, they may require you to do the Quadro, even though if you did it within 60 or 90 days or 6 months, even whatever the time frame was. So it's important to know what the rules are, what the requirements are for wherever the money is.
Let me read the first attendance code. So the first attendance code is 1942. 1942.
Great, thank you, Carl.
Okay, thank you, Carl. Also, some plans, some non-qualified plans that require DROs are supplemental plans. These are generally plans for higher executives in corporations. So they may have a pension, and because they're highly compensated people, they may have a supplemental pension over and above what is allowed to go into, under ERISA, there's restrictions, how much a person can be paid in under a pension. And I'm sure you've all heard or come across these restrictions, how much money you can put in your 401k, how much money you can put in your IRA annually. But these highly compensated individuals have supplemental 401ks or pensions. And you should always look for that when you're dealing with an individual that is a highly compensated employee. And often a DRO can be placed against those accounts as well. And those are not qualified under ERISA. The other thing, the qualified under ERISA, the company is getting all kinds of tax breaks, right, for providing 401ks or benefits to their employees. So that's why the other reason for the Quadros is that they have to be very careful that they don't violate any of the ERISA rules, because that could have tax implications to the company. Thus, the reason that these qualified domestic relations orders are required, so that they comply with ERISA and also that they comply with the individual regulations of that particular plan.
There's a question. Can a Quadro or domestic relations order be used after divorce, for example, post-judgment mediation or order? I'm going to assume that means it wasn't provided for in the judgment of divorce, because Quadros very often are drafted after the judgment of divorce has been certainly drafted, but even filed. So that can happen. I think the question might be, if you didn't say anything about the retirement asset and how it was to be distributed, or that you were supposed to do a Quadro, if you didn't say that in the judgment of divorce, can you say it later? I think you can. You might want to do an amended judgment of divorce by agreement, so that whatever the Quadro preparer needs, which Judy's going to talk about in a few minutes, whatever that person needs will be in a judgment, so that it's clear that that's what's supposed to happen and that the order is consistent with the judgment. So that can be done later if someone forgets to include it. But sometimes if you forget to include something and it would have been to your advantage to include it, and a judgment of divorce is entered, you're out of luck.
Yeah.
So that would have to be by.
Yeah, I see. I mean, I have come across multiple times that people have come back and said, oh, I didn't realize I had this pension, right? Or they come back to get the Quadro done post-judgment. And what Amy was saying is correct. Most people are writing that a Quadro or pensions or 401ks are to be divided in the judgment, and then the Quadro is being prepared post-judgment. So that's very common. The one thing that I do suggest to parties is you may want to put some type of language in your memorandum or your MSA that says, kind of like a catch-all, that should there be other retirement assets that have not been addressed here, the parties agree that those are to be divided. So that way, if post-judgment some other asset kind of pops up, and they do, you don't necessarily have to go back to court or amend the judgment because you have that catch-all in there. I don't know, Amy, if you think that's something.
No, I think that's a great idea for lots of reasons in lots of places, not just dealing with retirement assets. And I think a lot of agreements do say, if any other assets are discovered, this is how you're going to deal with them. So then that does happen with all kinds of assets. There's a question, it's actually in the chat. If a couple marries and sets up grantor trusts for their respective assets, does that remove the need for a Quadro if they subsequently divorce? I would think not. This is governed by federal law. I don't think that state estate and trust laws are going to preempt that.
No, they're not. They're not going to preempt the ERISA federal laws. I mean, I just agree with Amy. It's just not going to happen.
Yeah, because the plan administrator still has to know what to do.
Exactly.
So these don't pass through wills. Certainly, I don't know how they would pass through a trust. I don't do trust and estates law, but you're still going to need the Quadro, which is not a big deal. And you want to have it to make sure that you're not going to have a tax problem on a distribution. Okay,
Right.
so for a defined benefit plan, when it's time to draft the Quadro, Judy, what do you need to know? What should be in the MSA or PSA or the memorandum of understanding? And what do you need to know to get this drafted?
Yeah. So, I mean, the very first thing, obviously you need to get your documents, your statements. You need to know what plan the person is in, right? Is it a union pension? Is it federal, state? You need to know the plan. But the one important thing, first thing, is the person in pay status? Are they collecting on this pension, or are they still working and accruing, the benefits accruing for them? So that's your first question. If the person is retired, the only thing that you're going to be able to do for the other party is share the pension that is already being paid to the participant. You can't negotiate or discuss survivor options. There's really nothing that can be done. Once a pension goes into pay status, it's irrevocable. Whatever elections have been made, how that pension is being paid out. And in general, you're going to simply share the pension. You'll want to discuss with them how much each party should be receiving. I think generally, Amy, they do 50%, right?
Usually,
50% of the marital portion, not 50% of the entire pension.
correct.
So again, right, you want to know start dates. When did the person start in the pension? When did they retire? So dates are important when dealing with a retired individual, so that you know how much of that pension is to be shared. And really, that's it. I mean, there's more to it, but in general, that is all you're looking to do. When a person is not retired, the pension is still accruing its benefit. There are a few things that you need to look at. Again, dates. The coverture fraction that you've heard me and Amy speak about here it's the part of a pension that has accrued during the marriage. And that is New Jersey case law. I mean, that is, it's called the Marks formula or Risoldi. Look in my handouts, it explains it very well. Amy's handouts talk about how case law and the sites to them, but it basically says alternate payee, former spouse, entitled to marital portion of that pension at the time of retirement. So don't try to divide the pension as of the date of complaint or the valuation date. That's not going to happen because pensions don't have a day-to-day value like your 401k. You can look at look at a statement and say, this is what my 401k is worth. Pensions accrue their benefit based on length of service and salary at the time of retirement. So the pension doesn't really accrue its value until retirement. Alternate payee is going to get a fractional percentage, coverture fraction of that final benefit. But the things you must discuss, early retirement subsidies. Most people don't even understand what they are, don't deal with it. I'm going to give you a 1-minute example of an early retirement subsidy. So a participant in a plan is 57 years old, and the retirement age is 65 in that particular pension. But the company's looking to get new blood in, wants people to retire, they're older employees to retire. So they say to the employee, you can retire now at 57, and we're going to give you the same benefit as if you worked till age 65. So even though you've only actually accrued a $3,000 benefit right now, and if you stayed till you retired, it would be $5,000, we're going to give you the $5,000. Well, if you don't give the alternate payee or former spouse a piece of the early retirement subsidy, they're going to only share in the $3,000 that has accrued, not the $5,000 that the participant is actually getting. And if you have somebody that is talking about early retirement subsidies and they don't want to share it, they probably know they're coming close to getting one. So you have to be careful with that. And Amy, I believe there's case law out there, correct, that a former spouse is entitled to the early retirement subsidies unless waived. Don't waive that.
Don't waive.
Right? Yeah. Cost of living adjustments, same thing. And then the one thing that I always say when you're dividing this defined benefit plan is a pre-retirement survivor annuity. I don't want to get into the big specifics of it, but what sometimes in many pensions, if the participant dies prior to retirement, the pension actually goes away, even for the alternate payee. It's not the party's intention. So you just want to put in a qualified pre-retirement survivor annuity. Again, the handouts explain the reason for it and the thinking behind it, but that's very important.
So for defined contribution plans, what do you want to know? What do you want to see in the marital settlement agreement or the MOU so that you can draft that order appropriately?
Right. Contribution plans, I did touch on it, as you said a little earlier. You always want to have your valuation date in there, either date of complaint or another agreed upon, if in mediation, which I'm sure they do, it's a good idea, agree upon a date. You need to know whether earnings or losses are being assessed. So it's the percentage of the account or a dollar amount. Sometimes parties agree on a dollar amount. As of what date? Always a date. Even if it's as of the date of distribution. In other words, party says, we're just going to split this entire account, 50-50 each. Okay, but still say, as of the date of distribution. So there's got to be a date in there. There's got to be addressing earnings or losses. The loan. Always address the loan. Even if you say there are no loans against this account. Because I've seen parties, really have a disparate distribution because the loan was not addressed. There's a $50,000 loan and it's charged against one party and it shouldn't have been. You can have really disparate distributions. And premarital, which we've talked about. And those are really the four key points. And I think, again, one of the handouts that we gave you is called a pension checklist. Look at that one. That really gives you, points of what you should be looking at when defining the contribution plan. Think of anything else that you do when defining a contribution plan?
No, we need the dates, the percentage, the number, whatever that is. And again, I don't do set-offs. I want each one divided. I could say that 10 times. By the way, that's more business for Judy, but that's okay. Yeah. Because it's so worth it to get it right.
Right. And Amy, I'll talk to that. Listen, I don't, I'm not looking to get extra quadrants, right? I have plenty. But it is a penny wise and pound foolish concept, because taking Amy's example of the 100,000 and the 50,000, and if the valuation date is a year ago, right? If the person who had the 100,000, if their account only earned 2%, and so they keep, an extra 25,000, their 25,000 only made 2%. Whereas the other party is now, if their account went up 10%, so now they're keeping their account that had a 10% gain on the 25,000. You know what I'm saying? So it may look like they're saving money by not spending the extra, $500, $550 to get a Quadro done in the short run. But when those accounts are divided, they could be losing thousands of dollars.
Right.
I do suggest offsetting when you have a $5,000 account, a $3,000 account. Now, don't do Quadros against those, offset them. It's kind of like, cost benefit analysis when you're looking at these accounts. Is it worth the $550 to do the Quadro? How much would the percentage difference have to be to, for it to be not worth doing the Quadro?
Yeah. I did have a case. I don't remember why we did it this way, but we knew the dollar, we knew that we wanted to do a set off. And so we took one account. It happened to be an IRA, not a 401k, but it was an IRA. And we took that percentage of the IRA and simply moved it into another sub account. It's still the same IRA, or it could be, I guess, a different IRA in the same person's name. We're just a different sub account. So it's sitting there, and the alternate payee, until there's a distribution, would direct via the payee how that would be invested. So that was preserved.
Yeah,
We
that's
knew
smart.
that was the amount. And so
Right.
that was,
And you can do that
was
with an
recommended.
IRA. I'm not sure you could do that with a 401k.
No, I don't,
But
right.
And the other
Maybe
thing,
not.
Amy, that you maybe should talk about, because I've seen this coming into, is because of the change, I guess maybe in 2018, about alimony taxes, right, versus equitable distribution. So you have to be clear. Like occasionally I'll get something that says $200,000 for equitable distribution and alimony. Well, but the tax consequences are going to be different for equitable distribution payment versus alimony. So I think the parties need to make that clear with contribution plans. Am I right?
Yes, yes. So we have a couple of other questions. Can you
Oh,
speak
sure.
about divorce from bed and board regarding police, teachers, and corporate defined benefit plans, which are different? Judy's going to talk about police and teachers in a few
Yeah, we
minutes.
probably should get to that, right? Let's see.
Yeah, divorce from bed and board. I don't know what companies do, because I'm just going to talk about the companies now. I tell people, check to see if they'll accept it. Different companies, sort of, same with health benefits, whether the company is going to accept it or not. I don't know. I don't know that I've ever seen anything clear about how the government handles divorce from bed and
Yeah,
board.
I can tell
Maybe
you that-
somebody in the audience knows, but I certainly don't.
Yeah, the state, I can tell you as of today, and as long as I've been doing Quadros, the state does consider the parties still married under a divorce from bed and board. And I've seen, particularly for the police pension, which I touched on earlier, which has no survivor benefit for a former spouse, it is a way to keep the survivor benefit. Because if it is a divorce from bed and board, they are still considered the spouse of that police officer. So that is an option when dealing with that particular plan. In regards to, let me see, the question said, police, teachers, and corporate. Okay. The corporate is going to be, for each individual plan. But with corporate and even with the teachers, you see, you really don't need that protection anymore, because you can get the same protection for a former spouse through the Quadro that under the teacher's pension and in a corporate pension. The same, as long as the Quadro is filed. And I guess, Amy, we should talk about that, is that, the consequences of not doing the Quadro is where you get, it's very sticky. So as long as the parties are married, again, going quickly back to ERISA, a spouse under ERISA has certain protections. They have they're entitled to 50% of that pension, no matter what, unless they waive it. They have to sign and waive it. They're entitled to half of a 401k, as long as you're married. The minute the divorce goes through, all of those protections go away. And it's the Quadro that then says to the plan, well, no, this former spouse still has those same protections. This former spouse still has, a 50% interest in this pension or a survivor interest in the pension. Police is the only place you can't do it. Bed and board is a good option there.
Yeah, interesting that you're still married with the bed and board, but then you're not doing a Quadro. You're just maintaining your benefit because you continue to be married, correct?
Well, no, see, we do the Quadro so that the person gets their 50% of the marital portion. So they can still receive the benefit, the monthly benefit. But should the police officer decease the former spouse, they will then be considered the surviving spouse for the survivor benefit. Now, we still do the Quadro for it. And we do them for bed and board in both corporate and teachers and PERS. The only real clear benefit to it is it keeps the person as the survivor under the police pension.
Interesting. There's a question as to whether the Quadro can be filed with a judgment of divorce from bed and board. I think the answer to that is yes.
Yes.
And that's the best time to do it.
Yeah, exactly, right? It's good practice to file the Quadro at the time of the judgment of divorce. Any judgment of divorce, not even just bed and board. Because as I just said, once that judgment goes through, the former spouse now is a former spouse and loses all of the ERISA protections. The Quadro puts them back in place for the person. So yes, I mean, it's a great idea to get that Quadro filed with the judgment of divorce. I understand sometimes it's difficult, right, Amy, for practice purposes, practical reasons?
It depends. I think if you need time to do something, you can take the time to do it. At the beginning of this, we talked about assigning responsibility to one of the parties to make sure that their attorney makes this all happen. How that gets paid for, if it's going to benefit both parties, you can agree that they're going to split the cost for the attorney to do that portion of the finalization of the distributions, because it is perhaps more of a burden on one than the other. Although if you still have two lawyers in a case, one person's making sure it happens, but the other lawyer's got to review it and make sure that it says what it's supposed to say and that it also gets done. Certainly the person who is the alternate payee has more of an investment in making sure that it happens, because if it doesn't happen, they won't get the benefit. But assigning responsibility, really important, and doing it as soon as possible. I think it's just not something people think about, but they're really, unless you're doing this judgment on the courthouse steps, wherever those are virtually these days, there's time, because you know what you're going to be dividing. It's incumbent on, and this is a question, how much does the mediator get into the details? Does the mediator simply say, here are the 5 accounts, the parties are going to divide each account in half? If there's more that needs to be said, because there's a defined benefit plan and you have to talk about survivor rights or COLAs or early retirement subsidies, excuse me, that's something that's important to know up front. So again, my advice is, if you've got the plan documents and you're having difficulty kind of figuring out what they're really saying, and whether they allow certain things, call in an expert, call Judy, call somebody and say, how have you dealt with this in the past? Because they're going to know a lot about how that does or doesn't work. But it's a long answer to a quick question, I guess, but you should do these as soon as you can. And the mediator, really, if possible, can provide as much information as the parties can get a hold of, so that when the lawyers are doing the drafting of the final MSA, the information that Judy needs is going to be there.
Yeah, I have mediators call me frequently. I have them call me in the middle of the mediation and ask a question, can we do this, or how should we do that? It's a 5-minute phone call, 10 minutes at most. And it does make things so much easier and clearer. And I think too, the parties then understand, what they are settling on here. And I think that's a good thing. Also, the consequences of not doing the Quadro if the participant should die prior to the Quadro getting in place. Then you have all kinds of issues because they may have named somebody else as a beneficiary. The pension could be going to, if they've remarried, it's a quagmire if you don't get that Quadro in. So
Right.
I'm just, suggesting that and I think Amy's point of assigning responsibility is a great idea, so that at least it gets moving. Somebody knows this has to get done, because I have people come back to me 10 years after the divorce and the Quadro has never been done.
Let me read the, I'm sorry for interrupting you, Judy, but let me read the second attendance code, which is 0079. 0079.
Thank you, Carl.
Okay. People, it's 10 years, even later. I can't even tell you how many people come back a long time, and they're just lucky, that the pension didn't disappear. I have people who have come back and the pension has disappeared. So yes, good tip, practice tip to assign it.
Right. Also with 401ks, someone may have left a job and rolled over what was
Exactly.
in the 401k into a new 401k or into an IRA. And now you've got to try to track what happened. It really can be a nightmare. This should be done at the time you're doing the judgment, at the time you're negotiating. This really should be prepared to the extent possible. Okay, there's a question in here about HSAs. I have come across HSAs that are in one party's name and is to be shared. Discovered the plan administrator has rules. Does it need a Quadro?
I mean, I've done Quadros for HSAs. It probably comes down to what the plan requires, but yes,
Right.
we've done them. We don't have a lot of time. Amy, do you want to speak very briefly about state and local government?
Yeah, if you would, because those, we get lots of those and they are different.
Lots
So
of
if you could
those,
talk
right.
about that, that'd be great.
Right.
Thanks, Judy.
Again, we have a handout that was sent out, which is very helpful. But just, a brief overview. It's for New Jersey, it's Public Employees Retirement System, Teachers Pension and Annuity Fund, Police and Firemen, Retirement System. All of the states have very similar. New York has the same, Teachers, Public Employees, Police and Fire. So, and then there's federal government, different than the state. But they do all operate somewhat in the same manner, in that they only permit what's called a shared interest Quadro. So the pension always remains the participants. These separate interests that I talked about very briefly with corporate or private pensions, those pensions actually create those plans actually create two separate pensions, one for the participant, one for the former spouse alternate payee. These are private only. That's why those are, the death of a party doesn't really affect the other person. State plans, federal plans, shared interest, the pension remains the participant. All they're doing is sharing it with the other party. You must have a survivor. You must have a discussion about survivor. Do you want to designate the former spouse as a survivor on one of these pensions. There is a handout amongst all of this material, which you should, as Amy said, you should probably keep all of this material, but there is one, it's called fact sheet number 5. It's really a little golden piece of information because it tells you about all of the different survivor options available to a teacher's or a PERS employee. And you should, it's important to make sure that you have this discussion, because otherwise, should the plan participant predecease the former spouse or the alternate payee, all benefits will stop. And you know, some of these people, the pension is what they are counting on, right, Amy, as far as for their retirement?
Yes, it's very often the largest or among the largest of the marital assets.
Right. And if you have somebody who's counting on this pension in retirement, and then it ends on them because of the death of the participant, the person could really be in a lot of trouble as financially. So always look to what type of survivor option you want to give the former spouse. And just a quick tip is that, you know, sometimes people push back on the survivor option because it does reduce the benefit. There is a cost for that survivor option. But if there is pushback, know that the payment can be assigned to one party or shared by both. So you could say, former spouse to receive a survivor option, should she or he so desire, to be paid by them. The cost to be assigned entirely to them gives the participant less to be objecting to.
Right.
And the only other thing, again, I see we are running out of time. Military, very difficult. Military pensions, if you're doing one of those, you need to really take a look at what it is. And the one thing that people miss a lot for the survivor option in the military, it must be in place 1 year from the divorce or it's waived. So that is something that the parties need to jump on if there is a military pension. Make sure that the it's just called a court order, that the court order for the military pension gets done very promptly. Put in there that they have 1 year to get that put in. And the military is absolutely strict on that. 1 year and it's waived.
Yeah. Also, for if not an offset, and if not opting for survivor rights, are the parties able to obtain life insurance that would cover at least some substantial portion of the benefit to the alternate payee that they're now not going to get? That can be tough. In mediation, I mean, very often in mediation, the issue of life insurance comes up. If people don't have it, one of the things that you can ask them to do is to look into what it would cost for $250, for $500, for $1 million, whatever the number might be, that they can explore what's available, and if they qualify, because you don't want to put into an agreement that someone's going to get life insurance, and then because of some underlying health problem, they're ineligible.
Can't get it. Yeah. Now, if you're dealing with state employees, pre-retirement, it's a benefit. They have 3.5 times their salary in life insurance. Post.
Oh, she froze. Oh. See if we can get Judy back. I think what she's going to say, hopefully you can hear me, is that post retirement, if they still have the benefit, it's much reduced. And I think there might be something that they can elect, but it's much, much less. So it's important to know what you might need if life insurance is going to be something that you select. And I don't know what happened to Judy, but I think our time is just about up.
So you do have some more time if you want, but our time is up. Is she back? No, we lost her
No,
entirely.
We lost her. Maybe she's gonna come back in. Right, and Linda Spiegel notes you have to be careful with term life insurance. It ends at a certain age or becomes too expensive to continue. That's true. There's a point, if it's a 10-year term for 10 years, that amount of the premium is probably stable, but at the 10-year mark, depending on how old you are, that can double, triple, quadruple and become something that's just not affordable. So you do need to know what the term is and what the premiums are going to be over the length of that term, which may or may not be sufficient, but sometimes you don't have an option other than to get life insurance for something.
So doesn't look like Judy's coming back. We have
No.
reached the end of our time. Is there anything you want to add before we end the webinar?
I think just use experts when you don't know what to do. Get as much information as you can about how these plans work so that when you're helping people reach a decision about what to do with the plans, I always say, if you're making a decision about things, you need to know what those things are. So get the information, have the clients get the brochures, get the plan documents, and contact their plan administrators with questions so that this is done right.
Right. Well, I want to thank you very much. And Judy.
And Judy.
And
Yes.
Judy, who has disappeared on us. So that's the problem with always, we always have these possibility of technical problems. Again, thank you very much. It was really a great webinar. You gave us a tremendous amount of information and some things to think about. So thanks again. And
Thank
remember,
you.
everyone, we have the annual conference coming up on November 12th and the next CLE webinar, which is on December 6th. So everyone have a great week.
Thank you.